So today we're going to talk about finder's fees, earning commission on making referrals, essentially. So you hear people talk a lot about, hey, I've got some investors. Let me put them into your deal. Give me 10% of the amount they invest. Or I've got this company that wants to be acquired. Do you have somebody who wants to, purchase them or get involved? Or I've got a property I want to sell. Give me a percentage of the commission you earn off of the sale. So there's all kinds of different types of sort of referral and commission agreements out there. Now, the problem that comes into play is that a lot of times there's different laws in each state and on the federal level that govern these types of arrangements. And a lot of times when people come to me, clients come to me and they say, hey, here's what I'm working on, here's what I want to do, and let's just write this up in a contract. I look at it and I say, well, I can write it up, but it's illegal. The contract is not enforceable because what you're doing is illegal. A lot of times the types of commission or referral agreements that people want to put in place, and in all honesty, I understand in practicality, they happen all the time, and maybe they just don't get caught. I'm going to walk through an example of the SEC going after someone for finder's fees issues. But, I look at the contract is fine. I went to an event recently and they referred to a mutual referral agreement that's available online. I went and looked at it. The contract itself, I have a copy of it right here, mutual referral agreement. I read through it, nothing wrong with the contract. I mean, it covers pretty much what you're trying to do. However, it doesn't cover the fact that depending on how this is applied, it's not legal, meaning number one, the contract itself, if the content of what you're doing in the contract is illegal, not allowed to be done by law, doesn't mean you're going to jail, but by law, you cannot do this without maybe a license, then the contract itself is unenforceable, meaning if you're supposed to get a 10% commission from bringing investors in and they don't pay you your commission, if you're not a licensed broker dealer of securities, you probably can't enforce your contract. You take them to court, you try to sue them, and the other side or the judge looks at the contract and says, okay, you're supposed to get a commission. Are you a registered broker dealer selling securities? Because that's what you're doing. And you say, no, I don't have that. Why would I need that? Well, you're selling a security, you're selling an investment, and you can't get paid a commission without being registered or licensed through the appropriate authority, usually SEC and FINRA. There are different organizations that are involved in that. So if you're not licensed, then the actual contract itself is probably not valid and not enforceable. So then not only do they not have to pay you, contract's not enforceable, and a regulatory agency could decide to come after you. I'm going to go through an example to show you. Yes, it is rare, but it does happen. It's usually in connection with some type of fraud that occurs or misstatements that are made. So I'm going to show you an example of how that actually takes place and what the SEC does on a federal level. So I'm talking about different examples of finder's fees. So usually these take the form of, okay, well, I've got some investors and you're doing a real estate deal. Your company needs cash, whatever it is, you're putting a deal together to go acquire something. I've got, $1 million worth of investors. I'll bring them into your deal. You cut me in for give me a check for 5% when they bring their cash in, and we're good. That's a commission in exchange for basically the introduction. Now, there's a lot of gray areas here, and I do understand that the SEC even has different guidance on this, on what is or is not allowed, making basic, and certain states like California and Texas have sort of a limited finders, if you will, finder's fee exception. If it's straight just making an introduction only, nothing else. So they look at a number of factors. Is it just an introduction? Here's the phone number of the person as a potential investor. Feel free to contact them. And that's as far as it goes. And all they get is maybe a flat fee, $500 per phone number. Then it's not transaction based, like it's not a percentage of capital raised. Something like that might be okay. However, if there's transaction-based compensation, meaning you're getting something like a commission based on how much money you raise in, raise, how many securities you sell, because that's what you're doing. Then, and whether this is for a real estate deal or a company needs money, typically that's anytime you're raising money, it's usually a security. And so it's covered by securities law. And the SEC is the federal level. There's also state agencies that can go after this. Here's an example. Recently, this month, the SEC basically put an order out prohibiting some of these guys from ever basically involved in any kind of capital raise. But I went back and took a look from 3 years ago, the actual complaint dealing with this case. And just to give you an example of how some of this stuff can work, whether you're the person trying to get a referral fee, or maybe you're the company saying, hey, you know what? We really need cash. We don't know where to get investors. And this guy over here says he's got all these high net worth people he knows, angel investors. All we have to do is cut him a 10% check of what we raise, and we're good. So let's do some kind of deal with him. We'll sign an agreement with him to do so. So in this case, this company brought in about $600,000 from 14 investors. They were selling LP interests to invest in foot clinics, podiatry clinics in both Texas and Nevada. They actually had a private placement memorandum and other documents about the securities offering to invest, so investors could see what they were investing in. Now, it did cover things like whether commissions or percentages were being paid, and that said zero, including when they filed what's called a Form D. So when you raise capital, you're within 15 days, you have to file something called a Form D with the SEC. Basically says XYZ LLC has raised $1 million from 5 investors. They're all accredited and no commissions were paid in connection with the sale. Here's the people responsible for the sale. Some very basic information that gets filed with the SEC. In there, in this case, they said, no commissions are being paid. And the person signing it turned out to actually not really be the person in charge of this company. So they hired a bunch of people who were some of the named defendants to go out and essentially solicit investors. And so let's see, we can get into more of the specifics. Here's the list of defendants of what they actually did. So they were, now, first of all, we'll start off by saying that none of these people were registered broker-dealers of securities as required under securities law to go out and solicit prospective investors. So normally you need to be a registered licensed broker-dealer to basically cold call people and try to get them to buy ownership and invest in this company. So none of them were registered. So that's an issue right off the bat. Then what they were doing, and some of the problems that come for the company, is you start hiring these people and you don't have control of what they're saying or what they're doing. And essentially, they kind of tried to do a roundabout way where they weren't directly paying these people, I think it was 10 or 20% commission on how much capital they raise. They had a separate company that had a service agreement. Here's the main company that raises the money. Money comes in here. Then they have a contract with this other company that provides a service. So they're paying cash over here. Now, this company over here pays cash down to the people soliciting, the salespeople, if you will. So they're indirectly paying them a commission. And it was all based on a percentage of how much money they brought in. So, and the SEC goes through and says, here's the statement and here's why it's wrong. And the basis of these complaints primarily is fraud and securities fraud on a number of different levels, which essentially is a material misstatement or even an omission, failing to say something that misleads investors. So here's some explanation of the things that were misleading. In the PPM, it said that broker commissions would be limited to set $37,000. In reality, they paid $170,000 to unregistered brokers, saying that the funds were going to be used just for the business. However, they were actually diverted and just paid as commission, a large part of them. Okay, so the podiatry clinics, the purchases, a lot of the money would flow through what they call a skimming scheme, where percentages of the money to the podiatry clinics went back as commissions to the other people to indirectly pay them. Another thing that they talk about in here is the fact that the people involved in this, these salespeople that are not registered, they had prior issues with selling securities unlawfully. And so they were using aliases, they were using fake names so that nobody could look them up and see that they've been in trouble before. Okay, so they're saying the maximum amount they're going to raise is $500,000. They actually raised $518,000. The person, Stacy Marie Lira, was named as the managing partner and listed on the Form D, and actually had in reality, no control, no management, no involvement. She was a straw person. She had no connection really to this company. They were just using her name because they couldn't use their names because they've been in trouble before. Okay, so this goes into more of some of the misstatements and omissions that they're claiming they either knew or should have known were not correct, using aliases. Okay, the Form D filing, stating on the Form D that the managing partner was actually a figurehead. It wasn't even really the managing partner, saying there was no sales compensation, but in reality, 25 to 30%, 6% of investor proceeds were being indirectly paid out as commissions directly for the salespeople, even though they said zero was being paid out. Also, they didn't comply with securities law, that there was no exemption for, it wasn't a Reg D filing, or Reg D, essentially. Now, here's the problem from the company side. Let's say you hire somebody, you say, oh, here's a referral agreement. You got $10 million of investors. Okay, I'll give you 10%. Let's sign the agreement. Let's go. I need the money now. And I've been a CFO, I've raised capital, and I know that when there's deadlines and you need cash, people will do things that skirt the law. I understand that. I've seen it happen. But just understand that it can lead to trouble down the road because they hire these salespeople that, here's an explanation of some of the things that they were saying that were not true. So they talk with somebody and the person hasn't really agreed to anything yet, and to make an investment. So I'm trying to see if the name is in here somewhere, but they had sent it to someone to invest. And again, the whole thing of soliciting an investor by an unregistered broker is illegal. Then they start saying things that get the company in trouble. Hey, you already agreed to this. Now you got to give us that 60 grand you said you were going to. Please wire the funds immediately. They CC or copy their legal department to try to make it like more threatening. And there was actually no money due because no one had agreed to buy anything yet. Then they email him saying to put more pressure on, please wire ASAP. It's already set aside for you. These VIP units, it's the last unit. Thank you for buying it, which in fact was false. There was no such thing as a VIP unit. It was not the last unit being sold. They were just trying to put pressure and sales tactics to get the person's money. Again, talking about more things that were said during these calls that were just trying to force and pressure the person. So that's the thing, like you hire someone or you say, I'll give you 10%, bring these investors in. You don't know what they're going to say. And if they start making some of these claims or high pressure sales tactics, lying just to make a sale, it comes back to the company and the managers of the company that can get in trouble too for what's being said, not just the person saying it. So even when you have someone who is licensed, you need to have control over what they're saying and that they're not negotiating on your behalf, that they're not saying things that are not true, that are only referring to what's exactly in the PPM and been disclosed and reviewed and is accurate. So the high pressure sales tactics led the person to putting half of the amount, 30K, in to LFS funding. And the same day, they wired $6,000 for commissions to the person that made the sale. So even though they claimed it was this indirect payment, clearly it was just a straight commission for making that sale. So this talks about illegally acting as a brokerage. He went out and tried to find people to act as salespeople, essentially, that were not registered. He knew they weren't registered. He was doing whatever he could, and he offered to pay them 25 to 36% of the money they raised. And so they were paid through this supplier, Henderson Clinic, but it got its money from the investors. So even though it was indirect, it was a commission. Direct, like that was the whole point of it. And here's the list of payments made, the commissions. So essentially they come after them for securities fraud and for things that were being said that were not correct, for aiding and abetting. So they went after everybody, including those salespeople. So if you're thinking about getting involved in doing referral agreements, that's fine. Make sure you have it in writing, but make sure you talk to someone about the specific subject matter of what you're doing. So if you're bringing in investors and you're not a registered broker dealer, talk to an attorney, a securities attorney who understands the specifics in the state where you're located to know, okay, is there some type of way around this? If it's not transaction-based compensation, because there's factors that the SEC looks at, and some of the factors are here. Did the finder provide advice or engage in negotiation, or was it just an introduction? If you just say, I've got a list of investors, here you go, here's the list, then that's one thing versus, okay, I'm actually advising people, hey, this is a great investment. You really need to do this. If you start providing that kind of advice or negotiating terms, like, hey, if you go up to $1 million, I'm going to cut you in and you're going to get 20% of the company instead of 18%. So make sure you cut that bigger check. If they start getting into some negotiation or advising them, then they're probably acting as an unregistered broker dealer requiring licensing, or they even might be acting as an unlicensed financial advisor. Have they previously been involved in this? Have they previously sold securities or acted like this as a finder? Did they solicit potential investors? Did they go out and actively try to solicit people, or is it just people they knew they were talking to? And then lastly, the last factor that they usually look at is, did they get transaction-based compensation? So if you got somebody who's getting a 10% cut of the cash raised in a check in cash, that's transaction-based compensation. Now, or a success fee, like if you raise $1 million, I'll give you a $10,000 bonus. That might be transaction-based compensation. Something that you commonly see in real estate is, okay, well, the GP or general partner interest, let's just give them a portion of that interest. You help us raise money, you're providing a service, we'll give you 2% of our carried interest that we're getting, like a 20% split in the future. Kind of a gray area, because you're not cutting them a check for transaction-based compensation, like, okay, you raised $1 million, so I'm cutting you a check. It's, here's a level of amount you raised, you're getting 1% of our carried interest in the future, which may or may not even take place. If the project doesn't make any money 5 years from now when they sell it, that 1% of their 20% profit, there is no profit. So they really got nothing. So that's a little bit more common in real estate deals over the last few years as a kind of a gray area. I don't know that it's ever really been tested with the SEC in terms of would that can be considered transaction-based compensation, because they don't fall in the exception of being really a manager or controlling officer of the issuer of the security, even though they're kind of part of the GP entity, but they're getting a cut, a little split off of that. But is that transaction based if you don't even know if you're going to get anything? Like if there's no profit in the future, you get nothing. So that's kind of a way people have been going around it. One other thing that I have recommended to clients too is if you're going to do this, if they're a registered broker dealer, then that's fine. Still put it in writing. If they're not a registered broker dealer of securities, put a finder's fee agreement in place, not the one you find online, because that doesn't really cover what you need to cover. Put one into place that covers things like representations and warranties of the finder that they're not going to provide any kind of advice. They're not going to try to negotiate. They understand that they have to provide a copy of all PPM investor presentations and only follow specifically what's said in there. Do not make any kind of claims that are outside of those documents. And these are just protections. It's not a guarantee that number one, it would be enforceable, or number two, that somebody couldn't get in trouble for that later. But at least it's a little way to minimize risk and try to make the transaction not based on a split of how much money they raise. So mostly I've been talking about investors and raising capital through investors, but this can apply in M&A transactions, real estate deals. Anytime you're asking for like a compensation for a referral, a sale, like a commission, you always have to look at, okay, is this some kind of regulated thing that I'm doing? Do I need a license to do this? So you always want to check into that. And a lot of times it's based on the state where you're located, or also on the federal level, like with the SEC. And so you want to look into these kind of things, talk to an experienced attorney, do some research, make sure you understand before you start entering into agreements that the contract might not even be valid if you actually went forward with it and tried to enforce it. So I hope this helps a little bit. I have some other videos on finder's fees that also talk about some other areas of finder's fees. So thanks for watching. Make sure to subscribe.